Well, many people have been coming to Charles LeBlanc's defense since the blogger was arrested last month. Now, LeBlanc, as you know, is charged with criminal libel. The alleged victim is a member of the Fredericton Police Force. Fredericton City Councillor Jordan Graham called the arrest an attack on civil liberties. An IT technician worked to get LeBlanc's blog back online, and now the Canadian Civil Liberties Association has taken up the cause. The association has written to Fredericton's police chief, Barry McKnight, questioning LeBlanc's arrest and the seizure of his computer equipment. Nathalie de Rosiers is General Counsel of the Canadian Civil Liberties Association. We've reached her this morning in Ottawa. Good morning, Ms. de Rosiers. Welcome to the program.
Hey, good morning.
What is the association's interest in Charles LeBlanc's situation?
Well, the mandate of the association is to protect civil liberties throughout Canada, and so we often intervene in cases where there's some questions that need to be asked, and that's what we've done in this letter. We're asking the chief to reconsider and to make sure that indeed what he's doing is in accordance with the charter and with civil liberties. So that's we do that quite regularly, and often I think upon reflection, people may say, well, it sounded like a good idea, but it turned out that maybe it's not. So we're hoping that he might reconsider.
What infringement on civil liberties do you see in this case?
Well, the section that Mr. LeBlanc has not been charged under anything yet. He's just been arrested. But the charges that were suggested in the context of this arrest have been found the section has been found unconstitutional on 3 occasions, because obviously to be charged on a criminal libel is an infringement of freedom of expression, because it tells you cannot say that, you will be arrested for what you said or what you published here. It could be reasonable in a free and democratic society to maintain a criminal libel provision in the criminal code. The Supreme Court has said that, but it has said that in a context where it was limited, where there was an intention, where somebody willfully, intentionally committed a libel, wanted to really maliciously affect somebody else's reputation. And the section on which is charged does not have such limitations. So it's too wide, and that's why courts throughout the country had found it unconstitutional.
And what are the essential questions that you think Chief McKnight has to answer?
Well, I think he has to answer the questions, number one, what was the process to decide to use this very rare provisions, knowing that indeed it has been found unconstitutional throughout the country? Secondly, what was the role of the victim, was the police officer, in the arrest and in the seizure of the computer? Normally, I think we would expect for such arrest and such charging at least a consultation with the Crown, because, as I say, I think the likelihood of a conviction, the likelihood here of the section even being constitutional is highly debatable. So it feels like, although it's trying to teach Mr. LeBlanc a lesson, or it's just intimidation, and we just want to make sure that it has been done with all the proper safeguards that we should expect.
Can you suggest how this particular case should have been handled in order to not attract the attention it's attracted?
Well, I mean, in a democratic society, you may, even if you are, you think you're the victim of a libel, you could certainly either go to a lawyer and sue personally. But most of the time, what we suggest is it is a communications problem. I mean, if you think the story out there is not reflecting of the truth, then you tell your own side of the story, and that's one way. You can also, so that's a way. Yes, generally we suggest people do it instead of using the criminal code or making really quite a mountain and using public resources to solve, which is incorrectness and on the internet, well, you write your own stories and try to diffuse the criticism here.
And Ms. DesRosiers, have you had a response from Fredericton's police chief yet?
Well, not yet. I'm sure that he's consulting is the legal department, and we're hoping that he will reconsider.
Typically, when you intervene, the association intervenes. Do you get cooperation from the parties involved? Are you anticipating that the chief will respond?
Oh yes, we're pretty sure that he will respond. We have actually good cooperation in general from New Brunswick, from the government, and so on. At times we will get somebody to say, "Well, we've reconsidered." We've had that a couple of times last week, or at times people say, "No, we want to test the case in court and see because we feel strongly about it," and then we move to the next step, which is to seek clarification in the courts. And at times, obviously, there's a complete stalemate, but where people just do not want to engage in the debate at all. But so, and then we might consider the next steps that are necessary to ensure that the civil liberties are protected.
And what are those steps?
Well, I think you can in this case. Certainly, I think this will have to go to court. Either he will have to be charged somehow, and then we would probably intervene to suggest that the section is unconstitutional. It has been found unconstitutional in Newfoundland, in Ontario. To us, I think this is a case where it should not have been done the way it was.
Now, if the association decides that further steps are warranted, does that mean that you would provide legal representation to Mr. LeBlanc? Or would you act as an intervener, or how would that work?
I think usually we would go as an intervener, but if Mr. LeBlanc does not have representation, we will try to find him representation if he wishes. He may want to represent himself, but if we probably will try to find him representation. It works better this way because his interest may be to get this resolved, and we will want to make the point that the section itself is unconstitutional. So usually we try to find some counsel for the person himself, and we do make our point differently.
The association's intervention in this case really ratchets up the visibility of this case from a Fredericton story and maybe even a New Brunswick story to a national story. What are the possible implications for Fredericton on a national scale if you take this to court?
Well, indeed, I think it's important. It is a national story. I think to the extent that the section of the criminal code has been found unconstitutional in other provinces, and despite this, we wanted to make sure that the Fredericton police was aware of the legal risk here of pursuing the section. So that's one way. That's what we do generally. I mean, invite them to reconsider in light of the expertise that we have, which is to know a little bit what's going on around the country. But I do think that to have decided to use a provision of the code that is very rarely used, that has been found unconstitutional, I think they wanted to make a statement, and this may not have been the right thing to do.
So if Fredericton City Hall or the police department wanted to make this go away before it hits the national stage, what would the response be? What would you recommend they do?
Well, in a way, in a democratic society, if you are in a public office, and if you are a police officer, you have to expect, and I would say this because we often are ourselves being taken apart by bloggers. You have to tolerate that people will say things you don't like, and your responsibility, if you think that is sufficiently damaging, is to put out your own story. If you can always sue personally for civil damages, if you want, because in that context there are some provisions for the person to respond that and to defend themselves accordingly. In our view, I think this is a case where you simply ignore it and put out your own stories if you want to make sure that the right story is out there.
Is this a case where you think it would be appropriate for municipal officials, I'm thinking of the mayor specifically, to become involved or to have a comment on?
Well, I think it will be a question for them to decide. In our view, I think it's a bad use of resources to take this case to court, because the likelihood of success in light of the case law is very minimal. So it's a question of whether it's good judgment to do this. But I don't know what are the. I assume that the Crown's office will get involved somehow, and maybe in that case will reinforce, I think, the point that this may be an inappropriate way to proceed.
I appreciate your time this morning. Thank you so much.
Thank you.
Bye-bye. Bye-bye. Nathalie de Rosiers is questioning Charles LeBlanc's arrest and the seizure of his computer equipment. She is General Counsel of the Canadian Civil Liberties Association, and we reached her this morning in the nation's capital. Fredericton police are not confirming there is a charge against Charles LeBlanc and therefore will not comment on the case. Your thoughts on this situation are welcome. Please let us know what you think about how this is being handled. Info AM, all one word.